Hi guys, welcome to another segment of Legal Friday with me, Francine. So after my last segment on estate planning, I got quite a few questions actually, all asking the question, who do you choose to step into your shoes? And how do you go about choosing the trustee for your trust, or the executor for your will, or the agent for your healthcare directive, or the agent for your durable power of attorney? And I thought that was a perfect question because actually it's the next question it's the next important question that should be asked. So I think better than anything else I could say, the bottom line is you want to exercise care. You want to be thoughtful and you want to exercise care when you are choosing the person who's going to step into your shoes. Number one, whoever that trustee is, they're going to have to be a person who is able to manage the entire process. So you really want to choose someone who is willing and able to do the job. Now, a lot of times people come to the table and they can't do the job. So there are trainings, there are ways that you can help educate the person who's going to be your trustee or your executor if there's no trust in place. Either way, you want to make sure that they have a clear understanding as to what their roles and responsibilities are. Here's another thing. Even if they don't have the requisite skill, they always can ask for help. They can bring on a lawyer. They can bring on a CPA. But the bottom line is you want someone, if they are willing, if they are able, even if they don't have the skill, they know enough to ask for help. The other thing is you want to make sure that that person, whomever you put in place, that they are somebody who's willing to do what you want them to do, not what they want to do. So you don't want somebody who's going to be a lone ranger and who's going to say, well, I know what's best for you, so I'm going to do what I want. No, you want someone who's going to follow your direction. And the direction will be clearly stated, hopefully, in the trust or in the will. So you want somebody who has the requisite skill or is willing to ask for help. You want someone who is willing and able to do what you want them to do. The other thing that I'd recommend is you want to consider having the same person across all roles. The only exception might be the healthcare directive. In that case, you might, if you've got someone who has medical background, who you can also trust to do what you want them to do, then that might be the only exception. Otherwise, if you've got a trust, you might want to make sure that the trustee, the executor of the will, and the agent for the durable power of attorney are all the same. Again, you don't have to. Lots of lawyers don't even suggest that. I have always found in my experience that if those roles are occupied by different people, there's a potential for a problem because the trustee is the one overseeing everything, but the one who's the agent for the durable power of attorney, they're the ones who are in control of the money. And you do not want there to be a battle between the trustee, the executor, and the agent for the durable power of attorney. Why not? Because you want to really make it as easy as you possibly can for anyone who you've asked to step into this role on your behalf. You don't want them to find themselves in court trying to get something that they need when, in fact, if it was the same party across all of those roles, it would make it a lot easier. The only other thing I would request that you consider, and that is, it's easy to think that this is something that could just be left to chance. It's easy to think that, well, I'm going to put my best friend or I'm going to put my kids, and actually I have two kids and I really love them both. I'm going to make them co-trustees or co-executors. Just a thought. I always try to discourage clients from having co-anything. That means co-trustees, co-executors, co-agents for healthcare, co-agents for durable power. Why? Because that also could land them in court. And that's the last thing you want to do. You may think at the outset, here are two people, I know that they'll get along. I just know they will. Or you may say, I've got these two kids, I definitely know one is more qualified than the other, but I don't want to hurt the feelings of the other one. So I'm going to make them both co. I'll tell you, I have found it in my own experience as a lawyer that has not worked out. But Everyone's got to make their own decision, and ultimately it's the client that decides what they want. I would just recommend you consider not having co-anything. You can always have a successor, and I always recommend that my clients have not only a primary, so like the trustee, but then there should be a successor trustee and maybe a second successor. Likewise, with the will, there would be an executor and then a successor executor, and then as a second successor executor. And likewise with the agent for healthcare and the agent for the durable power. Why? Because what happens if that primary person is not able at the moment? Or what happens if they predecease you and you only had one person in that role? Then you leave it up to a court to make the decision on your behalf. Or what happens if the person is able and willing, but what if they're on an airplane and a decision needs to be made about your health care, just as an example? Or they're out of the country on a worldwide trip or in the Sahara having doing something and they can't be reached. So it's always a good idea to have a successor, because if you have a successor, if the first party can't be reached, or if they have predeceased you, then at least you know your back is covered. Okay, I think that's it for now. That answers the question, how do you choose your successor trustee, your successor executor, your successor agent for your healthcare, and your successor for your agent for your power of attorney. Until next week, I'm Francine. This is Legal Friday with me, Francine. Bye for now.